This is going to be video 2, Civil Practice, weeks 9 to 10, pleadings, and we left off with some general rules for drafting a complaint. Now we have general rules for drafting an answer. So now let's put ourselves in the position of a lawyer or lawyers representing a defendant in a civil case. What I didn't put in there, at least under the general rules, but I want to just sort of put you on the ground. In certain cases, particularly from the defendant's point of view, we would want to take a very close look and make certain that all of the factual allegations in the complaint do spell out a valid cause of action. And I'm going to tell you that it nearly always will they. But I've had a few occasions, not in car crash cases or divorces and so on, breach of contract, but in some of the civil rights type of cases where when you get into age discrimination, for example, that sometimes can be a little bit tricky from the plaintiff's perspective to plead. And conversely, if I'm representing the defendant, I'll ask myself this question when I'm reading the complaint. Hey, if everything here is true, is this a valid claim that's been spelled out? And if we don't feel it is, then we're not going to do an answer. We're going to go to court, not literally, right, but figuratively, and make a motion to dismiss the complaint on the ground it doesn't state a cause of action. More of that later, but that's something that we would do or consider doing. And we have to sort of have that on our checklist. But most of the time, we're going to end up doing an answer if we're representing the defendant. And the first mission of all answers is that they have to respond to the factual allegations in the complaint by either admitting them or denying them. And let's be real and acknowledge that most of the ones that are pivotal are going to be denied. So far, so good. But what we run into is this. In New York State, if we're going to deny, and we're going to be doing a lot of denying, our denial is going to have to be one of three types. Denial based on information and belief, and denial based on a lack of knowledge and that should be I apologize, information sufficient to form a belief. Blame the person who typed this, which was me. Okay, so we've got these three different types of denials. Interestingly, they all have the effect of a denial, meaning that the plaintiff is going to have to prove what we deny. And I'm sort of going to leave it to the law office that you're working in terms of how picky they're going to be about these three different types of denials. I am, but that might be a little bit old school. The answers I have in the handouts will walk you through, or if you read them, you'll see denials. You'll see denial based on information and belief, and you'll see denials based on a lack of knowledge or information, not of, or information sufficient to form a belief. Now, in addition to the denials, some answers are going to contain what's known as an affirmative defense. And an affirmative defense is a defense that just isn't reflected in the denial itself to the allegation in a complaint. For example, the complaint alleges negligence in a certain paragraph, and on behalf of the defendant, we deny it. That's certainly going to be a defense, but it's not going to be an affirmative defense. An affirmative defense is a defense then that, if you will, transcends or is greater than or other than, different from the scope of a denial. In a classic example, and you'll see that in the one of the answers we have, the first one would be in a car crash, comparative negligence. In other words, the defendant is raising as an affirmative defense, hey, they're not going to say it this way, but even if I was negligent, plaintiff, you were too, and your recovery should be based on the percentage your negligence contributed to the accident. And That's an example you're going to see in every car crash case of an affirmative defense. In addition to the admissions and denials in possibly affirmative defenses, an answer might also contain a counterclaim, which is a claim a defendant makes against the plaintiff for relief. It doesn't have to be, but typically it's related to the plaintiff's claim against the defendant. In a breach of contract case, for example, plaintiff is saying or alleging the defendant had a contract and the defendant didn't perform it under the terms of the contract. The defendant is going to, and the plaintiff saying, I'm damaged. The defendant is going to say, oh, no, plaintiff, you're the guy who, or person or entity who breached the contract. I was damaged. And so you're going to see counterclaims in breach of contract cases often. The counterclaim doesn't have to be related to the plaintiff's claim. Maybe these they're two businesses. They've been having different transactions, and the counterclaim concerns another transaction. So long as the counterclaim falls within the subject matter jurisdiction, the court's power to handle the case, then it can be properly asserted in the answer. And then we have finally the reply. I've given you an example of a reply. Again, if there's a counterclaim in the answer, then the plaintiff has got to respond with a reply. The reply is going to be really the first part and possibly the second part of the answer, meaning it's going to admit or deny the allegations in the counterclaim. And also it's possible there could be an affirmative defense to the claim set forth in the counterclaim. Finally, on this video, we're going to talk a little bit about verification of pleadings. And you can see in the complaint that there was a verification added to the complaint. And what is a verification of a pleading? It's actually an affidavit from the party submitting the pleading, in this case the plaintiff, that the party has read the pleading and what's contained in the pleading would be true to the party's own knowledge, except as to matters therein stated to be alleged on information and belief, and as those matters the plaintiff believes it to be true. We could ponder the value of a verification because I have some strong feelings about how useless they are. But the fact is, if you're working in an office that wants to verify everything, that's what you're going to do. And even if, like me, you think verification is kind of silly. Why do I say that? Because people who are going to lie are going to lie. It's not going to be like, oh my God, I've got to verify this. Let me tell the truth. At least that's my sense of things. I don't think, and even if you catch somebody in a lie in a verified pleading, I don't think that a district attorney in any county in New York State is going to say, oh, well, let's prosecute this person for a false statement under oath. I just don't think that's going to happen in a day and age of other crimes that are occurring. But there's people who have a much stronger belief in verifications. But if the law requires a verification, even if we have my skepticism for what it's worth, we still have to verify it. So certain pleadings have to be verified, including pleadings in divorce actions, pleadings in special proceedings, which would include then everything in family court, and pleadings that are responding to a verified pleading. So, again, you're going to have to figure out, as a paralegal or a new associate in a firm, where the firm stands about verifying pleadings that don't have to be verified. I think my sense is I cut my teeth, so to speak, in doing criminal defense work, and I've always had this distaste for having a client of mine state anything under oath unless absolutely it had to be stated under oath, because people make mistakes, honestly can make mistakes, but if you verified it, it can be, you can jam yourself up, I think. I just don't like it. And again, I don't think it does much good. But I don't want you ever saying in a job interview, oh, verification, it's bullshit. Please don't say that. And we have to verify if it's required. And again, you may be working somewhere where verification, the lawyers believe belongs right inside a church. Okay, that'll be it for this video.